I'm Duncan McLeod, and this is the TechCentral Show, brought to you today by MTN Business. Now, we've got a special guest in the studio today. Adv Pansy Tlakula is head of South Africa's Information Regulator, the entity responsible for enforcing the Protection of Personal Information Act, or Popia. Adv Tlakula, is it Popia or Popia?
Popia.
Popia.
Yes.
Okay. I wasn't sure how to pronounce that.
Yeah.
Popia. Then we'll try and get that right during our discussion today. But welcome. Thanks for making the time, and thanks for coming into our studio.
Thank you. Thanks for having us.
How long have you been heading up the Information Regulator for now?
We were appointed on the 1st of December 2016. So that makes it 7 years.
7 years already.
Yes.
Wow.
Yes.
Wow. Okay. But the genesis for the for this regulator actually goes a lot further back. It goes back to the creation or enactment of the the Protection of Personal Information Act. This entity was established, as I understand it, under that legislation.
Yes.
Tell me a little bit about that process. It seems to have taken quite a long time from the creation of the legislation to the creation of the regulator and then the capacitation of the regulator. Maybe just take us through the past 10 years and what it is you've been through and in the processes of setting up this regulator and where you are today.
Yeah, I think the law was adopted in 2013. And not much happened between 2013 and 2016. I think in 2015, then the Portfolio Committee on Justice and Correctional Services of the National Assembly, they then issued an advert calling for nominations for members of the Information Regulator, and a short list was done, and a number of us were shortlisted and interviewed. And after the Portfolio Committee interviewed us, it had to take the names of 5 recommended candidates to the National Assembly for a vote. And it's a simple majority vote. And after that, the names then were submitted to the President of the country, who then had to appoint the 5 members and designate the chairperson. So all that happened in 2016, and we then had our letters of appointment to begin a 5-year contract or tenure from the 1st of December 2016 to the 30th of November 2021.
Okay.
Yeah.
Why did it take 3 years from the legislation to the creation of the regulator?
I have no idea, really. No one informed me, except when I saw the advert in the newspaper, and I was encouraged to be nominated. And the reason for that really was not Popia. The reason for that was the fact that for the 12 years where I was a member of the African Commission on Human and People's Rights, I was also its special rapporteur on freedom of expression and access to information. So the regulator has a dual mandate. It is the protection of personal information and access to information, known as PAIA, you know. So because of the work that I had done on the continent on access to information, then that was the basis on which I was encouraged to put my name forward.
Okay. I forget about that second component of the Information Regulator's remit. So if I wanted a piece of government information that a government department isn't supplying to me, but which I believe should be a public document, I can then approach the Information Regulator and petition for access to that information?
No, you don't come to us first. No. You go to the department and you put a request for access to the Director General, who is the information officer. And then if you're not successful, you appeal to the minister. If you are still not successful, then you come to the Information Regulator to lodge a complaint.
How many such complaints have you received?
Oh, lots. But not as many as Popia. I think we have over 300 PAIA complaints. Compared to more than 600 Popia complaints.
And how quickly do you deal with those complaints?
Well, it takes sometimes, it depends on the complexity of a complaint. We could, for instance, because we also have the power to settle complaints through mediation.
Okay.
So if it's a straightforward complaint, for instance, if it's a Popia complaint and you complain that you were a customer of a particular company and after you left that company as a client or a customer, they did not delete your personal information.
Right.
We will then call the company. I mean, we'll do the formalities of writing a letter and so on. But we will then, have a conversation with the company to say, will you delete the names of this former customer of yours? And if they say yes, and then they sign a mediation agreement, and that's the end of the matter. So those kinds of, if they say no, which is not often, then the complaint will go through a full investigation. A full investigation of a complaint can take up to 3 months, depending on what it is, because complaints that relate to data breaches tend to take a bit long, because we then have to not only investigate the violations of the law, but we also have to bring in IT experts to look at the IT systems to determine what the reason or the cause of the data breach was.
I was going to ask if you have the capacity in-house to do these sort of investigations, because in the case of these data breaches, and I'm imagining you need some very specialized technical skills, people who are able to actually analyze how attackers entered into systems, and these are fairly rare and probably quite expensive skills. Do you have any of those skills internally, or do you always have to contract out for them?
At the moment, for the data breaches that we have investigated that have all gone public, such as DSCAM, such as DOJ, and others that are in the pipeline, TransUnion, we used internal capacity.
Okay, that's good to hear.
Yeah.
Okay, so you're able to find the skills you need, and you have the budget you need to be able to hire.
The budget is a problem because we're a startup.
Right.
And you asked about where we come from. I mean, in 2016, when we were appointed, there were 5 of us, 3 of us, including myself, were full-time, and 2 part-time members, and we met at the boardroom of the Department of Justice.
Okay.
Because we did not have offices. We had nothing except copies of Popia.
Right.
And we met, and we were supposed to establish this organization, and we looked at each other to say, what is it that we're supposed to do? Where are we supposed to start? Because all of us were lawyers, and with no organizational development background. I had some, because I was one of the original members of the South African Human Rights Commission in 1995.
Okay.
We started that commission, but I was led at that time by Professor Bani Pichane, who was the chair of the commission. I was one of the commissioners, but this time around, I had to lead the team to establish the Information Regulator, which we did. And I mean, we did everything ourselves. The organizational development stuff, we did it ourselves. We did benchmarking in Canada, in Germany, in the UK, sister organizations that have a dual mandate like us. We sat and went through thousands of applications for the CEO and the executives. So we basically established this organization from scratch, and also coming up with the logo, commissioning someone to come up with the logo. So I look back in 7 years, and we have almost 100 staff members. And we have an organization that is fairly known in the country. Lots of work still has to be done, but also quite recognized internationally as well.
Yeah. So your budget, is that entirely an allocation from the DOJ, or do you receive revenue from other sources? For example, you find the Department of Justice and Constitutional Development over a ransomware attack. Do you get to keep that money, or does that go into the National Fiscus?
It goes to the National Fiscus. We're having a conversation with National Treasury about that. And our budget doesn't come from the Department of Justice. Justice is a conduit.
Okay.
Yeah.
So it's an allocation from Treasury.
The reason is that when we started, Justice started us up and they helped us to establish the regulator. And there is a perception out there that we're part of Justice. And when we find them,
So
I remember someone saying to me, how do you bite the hand that feeds you? I said, no, that hand doesn't feed me. I'm fed by Treasury.
The DOJ can't have been too happy about this fine, though, after you worked with them so closely to establish the regulator.
Yeah, but that goes to, and it was quite interesting that I was speaking at a webinar 2 weeks ago. It was organized by the AU and African Union and the United Nations on internet governance. Mm-hmm. And that issue came because someone says, when we talk about independence of these kinds of institutions, I think the South African Information Regulator, showed that independence by finding an organization or a department that helped it to establish itself. Mm-hmm. So, yeah.
Well, take me through what's involved in chairing an information regulator. What does your day-to-day look like? Who are you meeting daily, and what decisions are you making daily? And
because Popia in particular, it's a new piece of legislation, and there aren't any experts. Mm-hmm. I think the experts that you find are probably the three of us or four members three of us who started in 2016. So, and the people that we have employed, they come into the organization also not having any Popia experience. Mm-hmm. So there is a lot of guidance that we need to give, but there is also a lot of debates that we have to have on the interpretation of Popia. So if, for instance, we come up with a guidance note on anything to guide responsible parties, which are companies, public and private bodies, once it is drafted, we have to sit down as members, led by myself, with the executive who drafted, to then look at whether that guidance note, is in compliance with the law. There are certain responsibilities that we have not delegated at all to the executives, like approving a code of conduct, because a profession, a vocation, an industry can adopt a code of conduct, like the Banking Association of South Africa, the Credit Bureau Association. They applied for a code of conduct, and we then the division will then draft a report on whether the code meets all the requirements of the legislation or not. But the decision either to grant or to reject that code lies with the members, led by myself. Like now we have just looked at the code of the Direct Marketing Association of South Africa, which is a big one on direct marketing, as you know, with unsolicited messages that people get.
Spam calls. I get 10 of them a day.
Exactly. So we looked at that, and we rejected the application. We sent it back to say the application does not meet or comply with the requirements in Popia.
Interesting. Well, while you're touching on the topic of spam calls, and I know I'm not the only one that is irritated by this. Literally, this morning before we did this interview, I've had 6 or 7 calls from some spammer called Press Play Now. It's an automated system.
Yes.
You pick it up, and no matter how many times I use Truecaller to block them, they find a way through again. Is there something the information regulator can do to stop these robocalls?
Let me tell you, the act, that one, the automated caller machine, it constitutes unsolicited electronic communication. And I think the challenge that we have, especially calls that are not automated, is on the definition of an electronic communication in Popia, which says it's a message that is stored in the network until it is retrieved.
Okay.
by the owners. So the big question, and the jury is still out on that, to say these calls that we get, not the automated ones, do they constitute an electronic communication or not? Some people say no, because it's a call that you receive. It's not stored. Then it's not electronic communication. Some people who are IT, they say these days all the calls are stored. So I'm a lawyer, I don't know. But what we are doing at the moment, I think that draft code of DMASA, the Direct Marketing Association, gave us the impetus to draft a guidance note on direct marketing. But what we have been doing to date is to kind of settle the complaints easily, but we have now decided that we just need to take one of those and
as
investigate it to the end.
Okay.
And we have potential violators that we are looking at.
Good.
Yes.
Because if we can end these robocalls, I'll be very, very, very happy. Do you think there needs to be a change to the legislation to make it clearer so that the regulator can go after these spammers?
Yeah. Probably quite a number of things in that legislation we have to look at them. I mean, also, if you look at the GDPR, for instance, and the law in the UK, a telephone call is regarded as unsolicited electronic communication. So we might need, depending on how the courts, because I suspect this matter on what constitutes an electronic communication, it might end up in court.
Yes.
So depending on what the court rules, we may need to amend the law. And the other part is that our law is quite cumbersome. The GDPR in Europe and the Data Protection Act in the UK, once they investigate you and they find that you have violated the act, they fine you immediately. With us, after we have found that you violated the act, we issue an enforcement notice in which we direct you to correct your wrongs. And within a period that we will have given you. Only if you fail to do that will we then issue an infringement notice to fine you, or if you so elect, to prosecute you.
Interesting. Yeah. Okay, so let's talk about the practicalities of this legislation and enforcement actions by the regulator. We know that data breaches are a big problem and seem to be getting worse. Certainly, we're seeing more and more incidents reported in the media. I don't know if that's because of the requirement for disclosure or because there is an explosion in cybersecurity incidents. But let's say I'm the CEO of a JSE listed company, or it doesn't matter who I am. Maybe I'm the Director General of a government department. My department gets hacked. My clients' or citizens' data is stolen in that incident. It's obviously often a very difficult time for companies because they don't know exactly what to do. Some companies perhaps have got practice books and have a way of dealing with this, and I suppose a lot of companies are looking at this specifically. But what is the general rule? What would you suggest to that CEO of that JSE listed company who's just been hacked, he's had 1 million customers' data impacted by this? Should he come to the Information Regulator first? What is the best practice here?
The law says they have to inform us once they have been breached.
Any breach?
Any breach. It doesn't matter whether the breach involves 1 million people or it involves one person.
Okay. As long as it's customer data involved.
As long as it's a data, personal information of a data subject.
Yeah.
That's what you have to inform us. Failure to inform us, it's a criminal offense.
Okay. And companies of any size are required even a startup, one-man company?
It doesn't matter.
Okay.
There is no threshold. In some jurisdictions, you find that there is a threshold in the law to say that if a data breach has affected so many data, subject, then you have to report. With us, there's no threshold. That's why you find, at the moment we're running from the beginning of the year at more than 1,000 reports of data breaches. Yes,
over 1,000 data breaches.
Over 1,000 of private and public companies that have reported to us their data breach. There are data breaches.
And when did this requirement come in for reporting? It's been there all the time?
It's been there since the beginning.
So that's since the beginning of this year. What was the...
No, it's been there since 20...
No, the figure of 1,000.
The thousands is
that's
now.
This year.
Yeah.
What was the number last year?
I don't have the figure, but it must have been over 600. There's a lot.
But it is accelerating.
I'm just saying that we are sitting dark as a country for data breaches, and I'm not...
Why is that?
I don't know. Maybe
is it geopolitical issues, nation-state actors involved.
Whether we have passed a cybercrime law because we don't investigate criminality.
Okay.
We investigate compliance with Popia when you've suffered a data breach. Our job is to check whether you had adequate, reasonable security measures in place to protect the personal information. That's what we do. But if there's an element of criminality, the police have to do that. So,
do you report it to the police, or does the company do that?
The company has to report to the police, because the company has to inform us, but they also have to, have to inform the data subjects.
Ah, right.
They can only delay informing the data subjects if there is a police if they've reported the matter to the police and the police say, so, just don't report yet. So, but we haven't followed with the police. I do know that, I think it was TransUnion, that data breach. They had
a ransomware attack.
There was a ransomware. There was someone who impersonated somebody very famous, and I think that person was arrested. That I saw in the media, that he was arrested, but I'm not sure how far the criminal.
It was in Brazil
is.
or something, if I recall.
No. Was it?
Was it local? I forget the details.
I don't know whether it was TransUnion or it was Experian. It was probably Experian.
Okay.
Because TransUnion, I think it was the Brazilians. I think it was Experian. With Experian, it was a South African.
Ah.
Yeah. And he's been arrested, and I know he appeared in court, but I forget the status.
These credit bureaus sit with a lot of detailed information about South African consumers.
Yeah.
Does there need to be more enforcement on those companies particularly?
I think so. I think so. I mean, we are finalizing we have finalized, in fact, we just have to consider it, the TransUnion data breach, which was actually quite interesting, because I knew about it because a journalist called me and said that my information was in part of the data that was hacked. Yeah. And I found that actually they had my old details, except the registration of my car. That one, they had it. So it was quite scary, actually.
And the criminals can use that for nefarious purposes.
Exactly.
Attack you, target you.
Yeah, and even in this country, identity fraud, it's a big thing. Yeah.
So how do you get tougher on credit unions, credit bureaus?
I mean, with the Experian one, we couldn't do much because that data breach happened before our enforcement powers came into effect.
And you can't do it retrospectively.
We can't do it. The Act does not apply retrospectively. The TransUnion one, as I said, I don't know, because the assessment has been completed, done by the division, the Popia. Now that assessment report has to come to us, and we're considering that next week.
Okay.
And we'll see. At the moment, I don't know what the assessment report says, because how the system is, if there's an assessment or an investigation, it is done by the division, the administration. And then if it's an investigation, they then take the report of the investigation to the enforcement committee, which is a committee made up of outsiders. It's chaired by Advocate Fourie. She's a senior counsel, and it has other external members and one member of the regulator. The enforcement committee will then consider the report of the division of the administration, and then make a finding and make a recommendation to us, members on the action to be taken. So that's how the system works. Even an assessment does not go to the enforcement committee. The division will conduct an assessment, and the assessment report comes to the members for a decision. So because of that, there is a very strict division of responsibilities for the purpose of fair administrative action. We can't be all things to all people.
Yeah.
So as I sit here as a member, I don't know what the report of TransUnion says.
Right.
I'll only know when we consider it next week.
If companies are not happy with decisions taken by the Information Regulator, do they have full powers to take it to matter on review at the court?
What is interesting in Popia, the Act does not talk about review, talks about appeal.
What is the significance of
So, you see, a review, you look at procedural fairness,
Right.
whether the process was fair, when you do a review. But the Act uses the word appeal, which means appeal, it's also the merits.
Yes.
That you go into. The first case that we are going to test this in court is DOJ, Department of Justice, because we just received the papers today
Okay.
to say they're challenging our decision. They
wow.
call it a review,
Yes.
but the law talks about appeal. So we'll see how this will play out in court.
Okay. So some legal precedent could actually get set here.
Exactly.
Interesting. We must follow up on that story. I wanted to ask about the DOJ actually and what the current situation is there. When you've imposed that fine on them, which I think was 5 million rand, there was some commentary, and I'm keen to get your reaction to this, because it seems like fair criticism to me. You here have a government regulator imposing a multi-million rand fine on a government department, which presumably is going to pay that fine if it agrees to pay it through using taxpayers' money collected from the taxpayer and given to the Department of Justice through National Treasury. Is this optimal? Should a government regulator be imposing a fine that's going to be paid at the end of the day with taxpayers' money? And does the Department of Justice actually learn anything through this process if the people involved are not feeling it personally in their own pockets?
Well, that's the scheme of the law, and unfortunately, that's how it is when it comes to these kinds of things. If you find against a government department, is it fair on consumers though, on citizens? Well, the only way in which we can avoid that, because we're a creature of statute, we do what the law says we must do. The only way that we can avoid that is if a department elects not to pay a fine, but to be prosecuted, and it's an election that lies with the department, or not only the department, or private or public body, anyone that we issue an infringement notice against. They have that choice. They may say, no, I'm not paying. I elect to go the criminal route.
Which is what they're doing. Well, they're electing to fight in court.
No, they are not fighting they did not elect to be criminally prosecuted. They are challenging the decision to fine them.
Understood.
Yes.
Understood, which is quite a different thing. Okay. So which court does that get heard in, by the way?
It's the High Court.
The High Court.
Yeah.
Okay, and then presumably the South African legal system will apply if they don't feel the High Court was fair. They can go to the Supreme Court and beyond that to the Constitutional Court.
Yeah, they can, depending on whether there's a constitutional issue. They can't just go to the constitutional issue unless they raise a constitutional matter.
Presumably the Information Regulator is going to want to pick these fights quite carefully as well, because you don't have an unlimited budget. You can't hire an unlimited number of lawyers to fight these cases.
Yeah, we're not taking anyone to court. We've got two pending. We are being taken. The first one that came, it's an interesting one. It's a PAIA one, actually.
Okay.
It is payment. It is information relating to payment of royalties.
Oh, yes.
To musicians. And that's what the complaint was about, to say this company that collected royalties had to disclose information on the royalties that were paid.
Okay.
And we investigated the case, and we then found that, in fact, the case went through the enforcement committee. And the enforcement committee then said, indeed, this information has to be made available. And that company is challenging
Oh, interesting.
that decision.
So
in court.
court papers have been filed.
Yeah, that one is, It's an interesting one. It will see how, because I mean, the issue of payment of royalties, as you know, it's a big issue in this country, not only here where artists, die very poor as paupers.
Yes.
So we felt that it was a case that we were very passionate about, because we felt that if that information was to be disclosed, it will change the lives of many people.
Yeah. What's the status with the Dis-Chem investigation?
It's done.
It's
dusted,
done. So all sorted?
All sorted. In fact, 2 days ago, they said they're complying.
Okay.
At first, they said, they had some issues.
They weren't very happy initially, I remember.
They were not happy, but they've now come back and they've complied with all our recommendations.
So everything's fine there?
Everything is fine with Dis-Chem.
Okay.
Yeah.
Good. There was a report in the Sunday World newspaper a couple of days ago. I don't know if you saw it.
Yeah, I saw it.
About the State Security Agency being attacked.
Yeah.
We've spoken to a number of people in government, including the spokesman for the Minister in the Presidency, Kumbuzo Ntshavheni, who has oversight of the SSA, and they said that this simply didn't happen. What is the status? Have you looked into this at all?
No, we are looking at two, because we can also do an own initiative investigation or own initiative assessment when we read about that. So there are two that we're looking at. It's the Department of Defense, remember?
Yes.
And then we are also going to be looking at this SSA.
At the SSA?
Well.
So you think there's something to it?
We don't know.
Don't know yet.
We don't know yet.
Remind me what happened at the Department of Defense? What was the story there?
It was also a hacking.
Hacking as well?
Yeah.
Okay.
They suffered a security breach. But, there's also a misconception. People think that if information was released negligently by one of the staff members, or if it was stolen, that's not a data breach. It is a data breach. For as long as you don't have adequate and reasonable security measures to protect the information against unauthorized access, then it's a data breach.
These things still happen, though. You could have a rogue employee who puts a USB stick into a laptop and copies a document. So sometimes there is almost no way of actually stopping these things from happening. Is the regulator lenient towards companies that... No.
Because it's a data breach.
Even if they've shown that they had all the systems in place that should have prevented it from happening.
I mean, if you have all systems in place to say we have taken all measures, but it still
happened.
We haven't come across anyone who has suffered a data breach.
Okay.
Where we felt that their systems were
good
in order and adequate. No.
Okay. All right. Okay. I'm interested to see what comes out of this SSA investigation. It's a very interesting one to see. Actually, on the topic of the public sector, it was the Transnet ransomware attack, which I think was last year, maybe in the year before. I don't know if that was before you were.
It was before our powers came.
It was. I was
going
to ask about
saw that one.
But there seems to be a lot of attacks on government entities, on public sector institutions.
Yes.
How much of a concern is this to the Information Regulator? And is there anything the regulator can do in terms of helping government protect its systems better?
It is a concern, because if we compare, the private sector and the public sector, not only insofar as data breaches are concerned, generally in terms of compliance with Popia, we find that the private sector actually, they are more eager to comply. They take compliance quite seriously. I guess because non-compliance does not only have reputational risk for them, but it hits their bottom line as well. And the reputational risk also is not only confined to South Africa. I mean, if you do business out of the borders of this country and you have suffered a data breach, that will not look good. Because we're dealing with a digital economy. That's where we are.
Companies don't want their names in headlines.
Exactly. So that is why I think companies take this more seriously, compliance with Popia more seriously than the
How do you get government to take it just as seriously as the private sector?
How do we do what?
How do you get the government to take compliance as seriously as companies do?
We have decided to to do road shows that will target government. We are doing a lot for government. I mean, like SASSA, for instance, is one of those government entities that are so consistent with requests for training. We do training for them in all provinces. That's the one government department or unit of the government that is very serious about compliance. You find some here and there, requesting us. But what we need to do is to just, spread the message. And because I don't even think at local government level, nobody knows anything about our act.
Local government seems to have bigger challenges.
We need to probably target SALGA, the South African Local Government Association, and also the provincial governments as well.
Okay. Last week, you announced that you are establishing a unit to investigate cybersecurity incidents. Just tell us a bit about what that unit's going to look like.
Yeah.
How big is it going to be? What's it going to do?
It's a security compromise unit because of the number of data breaches that we have. If we just wanted to have a unit that will just concentrate on the security compromises to fast track those that we need to close without further ado. Right. There are those. And also to identify those that, we need to investigate, to have a full investigation. So that's what the unit is doing because, as I'm indicating, we have a very large number of complaints on Popia. And on top of that, you have all these data breaches. Because if we don't have a specialized unit, companies or private and public bodies who have suffered a breach will inform us.
Yeah.
And after that, after informing us, what do we do with that? Something has to happen after they have informed us. So that's what that unit is concentrating on.
Okay.
Yeah. It has at the moment, I don't know, for now it has 4 people. I don't know, I can't quite, but I know there's a head of that unit. And we were still recruiting, particularly the people responsible for IT in that unit.
Just lastly, I wanted to ask you about how you work with other regulators. You mentioned that you traveled to other jurisdictions. I think you mentioned the US to learn from how they established their information regulators. Do you continue to work with those closely with those regulators at the moment? And how do you work with other regulators in South Africa, like the Independent Communications Authority of South Africa, for example, in the work that you do? Do you work closely with ICASA, with the Competition Commission and others? Competition
Commission, we have a memorandum of understanding, but there hasn't been much that we've done with them. The National Consumer Commission, that's another one.
I'd forgotten about that.
Yes, because the direct marketing issue affects them because their act says they can create a register. They call it a preemptive block of consumers who do not want to be contacted.
Oh, yes, I know about that list, yes.
Yes, and our issue is whether that list is compliant with Popia or not.
The list itself?
The list, because for them, people who say they don't want to be contacted for marketing purposes are in that list. Our question is, what about those who are not in that list? Can they be contacted? And the law says if you're not a customer for direct marketing through electronic communication, unsolicited, you have to give consent. And consent is specific, is voluntary expression of will.
Yes.
So it cannot be that because you are in a list that says you are not in a list of people who do not want to be contacted, you can therefore be contacted without your consent. So that's where we are with the National Consumer Commission, because they wrote to us to say they're now approaching the minister to bring that regulation into effect, the regulation that entitles them to do that preemptive block. So interesting. Internationally, because we are responsible for PAIA as well, access to information. So internationally, on the African continent, we have established the African Network of Information Commissions, and we are the chair. We chair that African network.
How many other African countries have established information type regulators?
15.
15.
And we have 27 that have laws altogether. But out of the 27, 18, I think around don't have oversight bodies.
All right.
So on the African continent, we chair the body. Internationally, it's called the International Conference of Information Commissioners. We sit on the executive. We've just been re-elected actually in the Philippines in June to the executive of, and that's on the access side. On the privacy side, it's called Global Privacy Assembly.
Mm-hmm.
There is the African part of it, which is called the Network of African Data Protection Authorities. We are members of that. It's not as strong. It's limping a little bit.
Okay.
And then on the global side, it's called the Global Privacy Assembly. We are members of the Global Privacy Assembly. We are also active members of the working group that looks at privacy as a human right, because I'm very passionate about human rights, and that's what I say, that we are a human rights organization. There is a very close link between the right to privacy, human dignity, freedom of expression, and access to information. So we're on that working group. In fact, next week, Friday, I'm leaving for Bermuda to attend the meeting of the Global Privacy Assembly, which is normally a big meeting, which has about 1,000 people. We have put our hand up to be in the executive of that Global Privacy Assembly, because the voice of Africa in that assembly is very muted. And we want to raise that voice. That is why we are not even joining virtually. We want to be there because we are a candidate. Of course, we have stiff competition, but we'll see how it goes.
I can think of a worse place to go for a conference than Bermuda.
Never been. Have you been? I don't even know how it looks like. But
somewhere in the Caribbean, I think. But
no, it's not Caribbean.
Oh, it's not in the Caribbean?
No, it's an island. People think it's part of the Caribbean.
Oh, it's not. Okay.
Because it must be very close also to the US, because to fly from Atlanta to Bermuda is 2 hours.
Oh, right.
So
but you're off the coast of Florida.
But it is definitely not part of the Caribbean.
I will go and look at Google Maps straight after this interview. Advocate Pansy Tlakula is chairperson of the Information Regulator. Thank you so much for making the time and sharing fascinating insights with our audience here at TechCentral. Thank you.
Thanks a lot. Thanks for having us.
Much appreciated.